On January 19, 2021, the Department of the Treasury issued a guidance in the form of frequently asked questions with regard to the $25 billion rental assistance program. In this video, I'm going to go through the guidance one question at a time and provide you with my commentary and interpretation of each answer. Coming up. Hey guys, if we're just meeting, my name is Vitaly Volpov. I'm a practicing attorney, an active real estate investor, and a part owner of a real estate brokerage in upstate New York. On this channel, I discuss relevant legal concepts as well as best strategies and tips for real estate investing and personal finance. If you're new to the channel, consider subscribing and hitting the notification bell so that YouTube notifies you of all my future content. If you enjoy the content in this video, hit the like button and comment down below. And as always, whenever I'm discussing legal concepts, just remember, nothing that I say should be construed as legal or financial advice. I provide this information for educational and entertainment purposes only, and you should always consult with your own attorney and your own advisor before making any legal or financial decisions. Last but not least, the views and opinions that I express in this video are my own alone and don't necessarily reflect those of my law firm or any of my business partners. Alright guys, so we definitely have some very interesting information that has come out with this frequently asked questions guidance. I'm going to take it one question at a time, and we're going to try to break this down and see what new information we can learn from it. The first question states that the statute provides that ERA, which is the abbreviation for Emergency Rental Assistance, may be used for utilities and home energy costs. How are those terms defined? The Department of the Treasury says that utilities and home energy costs are separately stated charges related to the occupancy of rental property. Accordingly, utilities include separately stated electricity, gas, water, and sewer, trash removal, and energy costs such as fuel oil. Telecommunication services, telephone, cable, internet, delivered to the rental dwelling are not considered to be utilities. Additionally, utilities that are covered by the landlord within rent will be treated as rent. This is very important. Essentially, any utilities that a tenant is paying themselves are going to be covered by this rental assistance program, meaning that a tenant who's behind on these utilities can receive rental assistance that will cover those utilities unless they're either included in the rent or they are telecommunication services. So you can't get your telephone bill paid, you wouldn't be able to get your cable bill paid or your internet bill paid from this assistance, but you can pretty much get everything else that is necessary in order for you to live in the household. The next question is, must a beneficiary of the rental assistance program have rental arrears? And the answer is no, they do not need to have rental arrears in order to qualify for the program. However, according to the terms of the program, grantees, that is, states and municipalities which will be distributing this program, are supposed to prioritize rental arrears first before they prioritize future payments for rent that hasn't come due yet. Additionally, the statute limits prospective payments to 3 months at one time. Question number 3, must a grantee pay for all of a household's rental or utility arrears? This is another important one. The answer from the Department of the Treasury is that no, the full payment of arrears is allowed up to the 12-month limit established by the statute if the arrears can be shown to be due to COVID-19. Grantees, again, states and municipalities, may provide assistance for an additional 3 months if necessary to ensure housing stability for a household. However, again, this is the important language here. However, a grantee may structure a program to provide less than full coverage of arrears. When structuring their program, grantees should consider how to best minimize any incentives for the non-payment of rent or utilities by potential beneficiaries of the program. So what this is saying is that states and municipalities do not necessarily have to pay out the entire arrears that is currently due. So as an example, if a tenant owes 6 months of back rent at $1,000, they owe a total of $6,000. This is saying that a grantee has the discretion to limit that to some fraction of the full amount. So in theory, a state like New York can decide that we are only going to distribute 50% of whatever arrears are currently owed. So instead of receiving $6,000, it's possible that under state rules, a person can only receive $3,000 because of the 50% limit that maybe the state decides to place on the assistance. One reason why a state might do this is if it feels like it doesn't have enough funds to provide assistance to every eligible applicant. Of course, this is not good news for both renters and landlords because essentially this is saying that states can decide not to pay back back the entire amount, even if they have the ability to do so at the time that you apply. So a landlord who's been struggling with their own payments may end up only getting 50% of what their tenant owes, and the tenant may end up having a debt of 50%, which may end up turning into a judgment if the landlord ends up deciding to sue the tenant in court and wins. Again, because the Department of the Treasury is allowing the states and municipalities to make their own decisions about how much of the arrears they're going to pay, this is likely to lead to varying results depending on where your property is located. Question number 4. What outreach must be made by a grantee, again, a state or municipality, to a landlord or utility provider before determining that the landlord or utility provider will not accept direct payment from the grantee? The answer from the Department of the Treasury is that grantees must make reasonable efforts to obtain the cooperation of landlords and utility providers to accept payments from the ERA program. Outreach will be considered complete if a request for participation is sent in writing by certified mail to the landlord or utility provider, and the addressee does not respond to the request within 21 calendar days after mailing. Alternatively, if the grantee has made at least 3 attempts by phone or email over a 21 calendar day period to request the landlord or utility provider's participation. All efforts must be documented, and the cost of the mailing would be an eligible administrative cost for the grantee. This provision relates to the fact that, according to the language in the new Stimulus Act under this program, this funding is supposed to go directly to the landlord or the utility provider and not to the tenant. The only way that this funding can go to the tenant is if the landlord or the utility provider does not respond to the efforts made by the grantee to reach out to them and let them know that this funding is available. So if you are a landlord and you want to receive this funding, you want to make sure that you're paying attention to your mail and that you're also responding to telephone calls and messages that government officials may be leaving on your voicemail. Aside from this, you should also be proactive with your tenants. You should speak with them and find out if they're looking to apply for this funding. Or, even better, apply for them. Work with them to apply for this funding. Don't just sit around and wait for this to happen. Find out what agency is administering the funding, then talk to your tenants, get together with them, get the right information, get the application forms, fill them out, and send them in as soon as possible. Like I said, the estimates are that the total arrears for rent and utilities is much smaller than this $25 billion funding. So you want to be one of the first to apply to make sure that you actually receive something. Question number 5 states, the statute limits eligibility to households with income that does not exceed 80% of area median income as defined by the Department of Housing and Urban Development, but does not provide a definition of household income. How is household income defined for purposes of the ERA program? How will income be documented and verified? So the Department of the Treasury identifies 2 ways to define household income. The first way is by using the definition of annual income that the Department of Housing and Urban Development uses in its regulations. The second way is by using the adjusted gross income definition from the IRS Form 1040. Either of those will work in order to prove household income for the purposes of this program. The Treasury Department also says that for determining annual income, grantees should obtain at the time of application source documents evidencing annual income. In other words, wage statement, interest statement, unemployment compensation statement, and so forth, or a copy of Form 1040 as filed with the IRS for the household. Now, although this answer does not say what year the Form 1040 is supposed to pertain to, I think that they're talking about 2020 and not any other years. Remember that the eligibility for this program started on March 13, 2020, and is supposed to continue through the end of 2021. So right now, the only Form 1040 that would make sense would be the one that you would file for your 2020 taxes. Now, with regard to the 80% of area median income threshold, this can be determined in one of 2 ways. One way would be by having the state or the municipality look at an applicant's annual income, which can be shown by using one of the 2 methods we just discussed. The other way would be by looking at an applicant's monthly income. And in that case, for determining monthly income, grantees must obtain income source documentation as listed above for at least the 2 months prior to the submission of the application for assistance. If an applicant qualifies based on monthly income, income, the grantee must redetermine the household income eligibility every 3 months for the duration of assistance. So if you're able to show that you meet the 80% of the median income threshold by using your monthly income, you may be required to resubmit and provide additional proof in the next few months in order to continue to receive your rental assistance going forward. So generally speaking, it would be better if you can meet your eligibility requirements with regard to income by using your annual income rather than your monthly income, because when you use your annual income, you do not need to reapply and provide additional documentation to your state or your municipality. Question number 6. In addition to providing an attestation in writing, must applicants document that they have experienced a reduction in income, incurred significant costs, or experienced other financial hardship due to the pandemic outbreak? The answer that the Department of Treasury provides is yes. To the extent administratively feasible, grantees must require applicants to document that they have 1. Qualified for unemployment benefits, or 2. Experienced a reduction in income, incurred significant costs, or experienced other financial hardship due directly or indirectly to the pandemic that threatened the household's ability to pay the costs of the rental property when due. The Department of the Treasury also goes on to say that grantees must also require applicants to demonstrate a risk of experiencing homelessness or housing instability, which may include past due rent and utility notices and eviction notices, if any, as part of the application process. So the states and municipalities are expected to request applicants to provide them with documentation supporting their eligibility based on these criteria. Exactly what documents will be needed in order to prove eligibility should be discussed and detailed in your state or municipality's application instructions. Once my home state of New York opens up its application process and provides instructions, I will do another video following up specifically with regard to New York State. Number 7, is there a requirement that the eligible household have been in its current rental home when the public health emergency with respect to the pandemic was declared? The answer is no. However, payments under ERA are to be provided to households to meet housing costs that they are unable to meet as a result of the pandemic. There is no statutory requirement for the length of tenure in the current unit. So if you're a landlord and you had a tenant who moved into your property in June of 2020, let's say, and then in September of 2020, they started having financial difficulty as a result of the pandemic, that tenant would technically be eligible as long as they meet all of these other criteria that are required. The same thing goes for a tenant who's been in your property for a few years and just recently started having financial difficulties. Either way, the financial difficulties that have resulted from the pandemic, as long as they occur after March 13, 2020, would be covered and eligible for this type of assistance. Question number 8. What data should a grantee collect regarding households to which it provides rental assistance in order to comply with Treasury reporting and record-keeping requirements? And here the Department of the Treasury lists quite a few pieces of information that grantees will likely request from applicants. They will require the address of the rental unit, the name, address, and social security number or tax identification number of the landlord or utility provider, the amount and percentage of monthly rent, the amount and percentage of separately stated utility and home energy costs, total amount of each type of assistance received, amount of outstanding rental arrears for each household, number of months of rental payment and number of months of utility or home energy cost payments for which ERA assistance is provided, household income and number of individuals in the household, and the gender, race, and ethnicity for the primary applicant for assistance. Now, according to the Department of the Treasury, this is not all of the information that can be asked and retained by the grantees. There may be additional pieces of information that will be required. So obviously, check your state or your municipality's application instructions and provide them what they're asking for there. Question number 9, the statute requires that ERA payments not be duplicative of any other federally funded rental assistance provided to an eligible household. Are tenants of federally subsidized housing, e.g. low-income housing credit, public housing, or Indian housing block grant assisted properties eligible for ERA? The answer to this question, according to the Department of the Treasury, is yes, they are eligible. However, there are some limitations with this. If an eligible household receives a monthly federal subsidy, in other words, a housing choice voucher, public housing, or project-based rental assistance, and, this is the important part, and the tenant rent is adjusted according to changes in income, the renter household may not receive ERA assistance. So if a tenant's public assistance was adjusted based on the reduction in rent, the tenant would not be eligible for assistance for the difference that's created between what rent used to be and what rent is now, because essentially they're not being charged the additional rent. Question number 10, may a grantee provide assistance to households for which the grantee is the landlord? The answer is yes, a grantee may provide assistance to households for which the grantee is the landlord, provided that the grantee complies with all the provisions of the statute and this guidance, and that no preferences beyond those outlined in the statute are given to households that reside in the grantee's own properties. So this is a situation where a city or a town owns public housing which tenants are renting, and where tenants have gotten behind in their rent as a result of the pandemic. In that case, a town that applied and received the funding from the federal government would be considered a grantee and also would be considered a landlord. And as long as that grantee does not create any additional preferences other than what's described in the statute, that grantee could use those funds to pay for any arrears that those tenants owe to the grantee. Question number 11, may a grantee provide assistance for arrears that have accrued before the date of enactment of the statute? The answer is yes, but not before March 31st, 2020, the date of the emergency declaration pursuant to subsection 501B of the Robert T. Stafford Disaster Relief and Emergency Assistance Act and the section that it cites. So the new Stimulus Act became law on December 27, 2020. And this question is basically asking, can you get rental assistance for arrears occurring prior to December 27, 2020? The answer to that is clearly yes, but not before March 13, 2020. Any arrears that preceded that date would not be eligible for this assistance, and it would be only arrears that occurred after March 13, 2020, going forward through December 31st, 2021. Question number 12. May a grantee provide assistance to a renter household with respect to utility or energy costs without also covering rent? The answer to that is also yes, in that a tenant may be current on their rent but behind on their utilities, and they would still be eligible to receive this type of assistance. The other thing with this type of need for assistance is that utility payments, unlike rent, do not have a 3-month limitation on prospective payments. So in theory, someone who's eligible for this program could receive assistance for utilities from the date on which they apply all the way through the end of the program period, which is December 31st, 2021. Question number 13. May a grantee provide ERA assistance to homeowners to cover their mortgage payment, utilities, or energy costs? And unfortunately here the answer is no. The statute requires that ERA assistance be provided only to eligible households, which is defined to include only households that are obligated to pay rent on a residential dwelling. A lot of people have asked me about this and have rightfully complained, saying that there is assistance that is being provided to renters, but there's nothing being provided to homeowners who have their own mortgages. Some of those homeowners are struggling the same as renters because they've lost their jobs as a result of the response to the pandemic. And I absolutely sympathize with you on this, but unfortunately this program does not provide that type of assistance. Hopefully there will be some assistance coming down the line for homeowners that is not currently available. Finally, the last question, question 14, the statute provides that ERA funds may be used for other expenses as related to housing incurred due directly or indirectly to the pandemic as defined by the Secretary. What are some of the examples of other expenses? And the response here from the Department of the Treasury is that the Secretary of the Treasury has not made such a determination at this time. This may change in the future, but right now there are no other expenses for which this assistance could be used. So that's it for the frequently asked questions from the Department of the Treasury. I will update you guys if there are any new developments with regard to the Emergency Rental Assistance Program. But for now, that's going to do it for this video. If you have any other questions about anything that I covered in this video, or if you have other questions that I didn't cover, please drop them in the comments section below, and I will try to answer them to the best of my ability. Thank you guys for watching this video. If you enjoyed it, do me a favor and hit the like button. If you haven't yet subscribed to my channel, definitely subscribe so that you don't miss any of my future content. Have a great day, and I will see you in the next video. Take care.